Welcome to the deep dive. Today, we're really getting into the legal complexities of divorce. Our goal is to unpack the core requirements, the main reasons or grounds for ending a marriage, and also some surprising legal defenses, the bars, that can actually stop a divorce. We'll be using legal notes and some really interesting court cases.
Yeah, and the source material is fascinating. It's basically detailed notes on divorce law key definitions, what someone seeking a divorce, the petitioner, needs to do, and like you said, a lot of important court cases. Now, many are Ugandan cases, but they shed light on common law principles that apply more broadly. Really shows how law handles something so personal.
Okay, so let's start right at the beginning. If someone's looking for a divorce in, say, Uganda, what's the absolute first thing they need to prove, like the foundational step?
Good question. So the petitioner, the person asking for the divorce, they basically have to prove three key things right off the bat. First, that there is a valid marriage, and crucially, that it's domiciled in Uganda. Domicile just means that's its legal home base, giving the court the right to hear the case.
Okay, so valid marriage, legal home base. Got it. What else?
Second, they have to lay out the specific legal grounds for the divorce. We'll definitely get into those. And third, they need to show there aren't any bars to the divorce. These are like legal roadblocks or defenses that could stop it, even if a ground seems to exist. And something really important here is about gender equality. You know, historically, it wasn't always a level playing field for husbands and wives seeking divorce. But there's a huge case, the Uganda Association of Women Lawyers v. Attorney General, people often call it the FIDA case. The Constitutional Court basically said, look, every ground for divorce in Section 4 of the Act, it applies equally to both the husband and the wife.
So no more different rules for men and women on why they can ask for a divorce.
Exactly. It was a major step. Section 4, subsection 2 even specifically mentions a wife's ability to petition. But this case made all grounds universally available. It really changed things, making the law see marriage more as an equal partnership, legally speaking.
That's a really fundamental shift towards fairness.
Mm-hmm.
Okay, so assuming they established the marriage is valid and the court has jurisdiction, what are those specific grounds? What kind of faults or situations actually justify dissolving the marriage in the eyes of the law? Right, let's get into the nitty-gritty. The big three grounds often cited are adultery, cruelty, and desertion. Let's tackle adultery first.
Okay, adultery. Legally, it's defined pretty clearly in cases like Habyarimana. It means consensual sexual intercourse during the marriage between one spouse and someone of the opposite sex who isn't the other spouse. So basically, sexual intercourse involving at least one married person, but not with their husband or wife.
Pretty straightforward definition.
Yes. And courts, like in the Dr. Kazibwe case, emphasize it's a distinct ground. It's not just a type of cruelty, it's its own thing. And as we just mentioned, thanks to that FIDA case, it's available for either spouse to use.
Okay, but proving it, that seems like the hard part. How do you actually prove adultery happened in court? Direct evidence must be incredibly rare.
You absolutely hit on the challenge there. Yeah, direct evidence, photos, videos, almost never available. So the burden is firmly on the petitioner. They have to convince the court. Often what lawyers do is look for corroboration, evidence from conduct before or after the suspected event. Cases like Ruhara v. Ruhara mention this. And crucially, adultery can be proven by circumstantial evidence. So no smoking gun, maybe, but if all the surrounding facts point so strongly towards adultery that there's no other reasonable explanation, the court can accept it. It has to be cogent, as the law says. Compelling.
Right, building a case from the circumstances.
Exactly. And there's this wild case, Preston Jones v. Preston Jones, back in the 40s. The husband was out of the country for 360 days straight. No way he could have visited.
A long time.
Right. And during that time, his wife had a baby. He petitioned for divorce. The court looked at the timeline, the biology known then, and basically proved beyond reasonable doubt he couldn't be the father. Divorce granted on adultery.
Wow. Based on the timing of the birth.
Yeah. It shows how powerful strong circumstantial evidence can be. Oh, and one more thing. The person petitioning, the petitioner, generally needs to be innocent themselves. You can't really petition based on adultery if you've also committed it.
That makes sense.
Yeah.
Okay, moving from adultery, what about cruelty? This sounds like it could be much wider ranging, maybe more subjective than adultery.
It definitely is broader, yes. Cruelty isn't just physical violence. It can be physical, yes, but also mental, or what's sometimes called legal cruelty. And like adultery, it's a distinct ground, open to both spouses. The Kazibwe v. Kazibwe case even noted husbands can be victims of cruelty too.
So the law doesn't actually define it strictly.
No, the Divorce Act doesn't give a precise definition, so its meaning has really been shaped over time by judges through case law, what we call judicial creativity. The core idea, coming from cases like Habiramana and Casa v. Casasa, is conduct that causes actual or apprehended danger to the petitioner's physical or mental health.
Danger to health, physical or mental. Okay.
And for it to count as legal cruelty, it needs to be serious. It has to go beyond the reasonable wear and tear of married life, the everyday ups and downs. There's a really stark example in Mary Ruhara v. Christopher Ruhara scalding someone with burning oil. The court called that the most cruel and brutal act. Obviously extreme.
Clearly. But you said it's not just violence.
Right. It can also include things like constant injurious reproaches, complaints, accusations, and taunts, really harmful verbal and emotional stuff. When looking at that, the court has to consider the whole matrimonial relationship, not just isolated incidents.
So if it's not strictly defined, and it includes mental harm and the whole relationship, how does a court decide? What factors do they actually look at to say, yes, this crosses the line into cruelty?
That's the key question. Courts look at a whole range of things. It's very context dependent. They consider the impact of one spouse's personality and behavior on the other. They look at all the incidents, the quarrels, the general atmosphere. The mental and physical health of both parties is important. Even their characters and sometimes their social status can play a role. Kagimu mentions these factors. It's a really holistic view.
A holistic view, okay.
And you get some really interesting situations where things you might not immediately think of as cruelty have been found to be just that, like denial of sex or refusing to have children.
Really, how does that work legally?
Well, take the practice of coitus interruptus withdrawal. Cases like White v. White, Walsham v. Walsham, Cackett v. Cackett found this could be cruelty. The reasoning wasn't just the physical act, but the emotional and psychological impact, the violation of expectations within the marriage, causing distress.
That's quite intimate for a court to rule on.
It is. And similarly, in Bravery v. Bravery, a husband had a sterilization operation without telling his wife, without her consent. She wanted more children. The court ruled that was cruelty. He disregarded her feelings, her wishes, her sort of bodily autonomy in the context of their shared life.
So it's about the impact and disregard, not just the act itself.
Precisely. Now, the burden of proof for cruelty, it's a bit higher than the standard civil balance of probabilities. More likely than not, it needs a bit more weight. But it's not as high as the criminal standard of beyond reasonable doubt. Gakwa v. Gessinger clarified that.
Okay, slightly higher bar, but not criminal level proof. Got it. That really shows how complex cruelty can be legally. Let's shift to the third ground. Desertion. This one seems to have a time limit attached. What exactly is desertion?
Yes, the time element is key here. Desertion is when one spouse petitions because the other has basically abandoned them for a continuous period of 2 years, and importantly, without a reasonable excuse. Kazibwe v. Kazibwe mentions this. Now, the Act doesn't define it, but cases have broken it down into 5 essential elements.
5 elements. Okay, what are they?
Right. 1, there has to be a physical departure, a withdrawal from living together. 2, there's a de facto separation, meaning they are actually living apart. 3, the deserting spouse has withdrawn from cohabitation, stopped living together as husband and wife. 4, this is critical, the intention to desert to end the marriage for that 2-year period. Lawyers call it animus disserendi.
The intention to end it.
Exactly. And 5, there's no reasonable excuse for leaving, and the spouse who was left didn't consent to the departure. Oh, and the desertion must still be happening when the divorce case actually starts.
Makes sense. It has to be ongoing.
Yeah. A good example is Dr. Joseph Irum v. Deborah Kumugisha. The judge found the respondent had no good reason for leaving and granted the divorce. And Lord Porter, in a case called Lang versus Lang, put it really well. He said you need 2 things for desertion: the outward and visible conduct, the physical act of leaving, and that internal intention, the animus disserendi, the desire to bring the marriage to an end. Both have to be there.
So it's behavior and mindset.
Absolutely. And the burden of proof can shift. In Patel v. Patel, the court said, once the petitioner shows the other spouse left without consent and didn't intend to return, the onus is then on the spouse who left to prove they had a good reason. That case also touched on consent. If you initially agree to live apart, maybe conditionally, but that condition isn't met or the consent is withdrawn, then staying away can become desertion.
So an agreed separation could turn into desertion later. That's tricky. What about this idea of constructive desertion, where someone doesn't physically leave, but their behavior forces the other person out.
Right, constructive desertion. It's a concept basically created by judges over time. It happens when one spouse's conduct is so bad, so intolerable, that it essentially makes it impossible for the other spouse to stay. They're effectively driven out, as one judge put it in Boyd v. Boyd.
So the person causing the leaving is considered the deserter.
Exactly. The test is really whether they're truly living together as husband and wife anymore because of that conduct. The intention to end the marriage might not be stated, but it can be inferred from the behavior.
Okay, but proving that intention must be hard too.
It can be. There are some really memorable cases. Bartholomew v. Bartholomew, the husband left because he said his wife was just too dirty. Yes. But the court said, well, maybe she's just lazy. Her being dirty doesn't automatically mean she intended to drive him away. Her conduct wasn't grave and convincing enough to infer that intent. So, ironically, he was found to be the deserter for leaving.
Wow. Okay.
And then there's Winnin v. Winnin, famous case. The wife apparently preferred her cats to her husband, spent all her time with them.
The cat lady case.
Sort of, yeah. He left. But again, the court said her obsession with cats, while maybe annoying or eccentric, didn't necessarily show an intention to end the marriage, so he was the deserter. It really underscores that the intention behind the conduct, or inferred from it, is key for constructive desertion, not just difficult behavior.
Those examples really highlight the focus on intent. Okay, we've covered the grounds, but even if someone proves adultery, cruelty, or desertion, you mentioned there are bars, things that can stop the divorce. Let's get into those. What are they?
Right, the bars. These are like defenses. Even if a ground exists, if one of these bars is proven, the court might refuse the divorce. The first one is collusion.
Collusion. Sounds like conspiring.
Pretty much. It's defined as an improper agreement or bargain between the spouses, basically to trick the court into granting a divorce. Like, maybe they agree one will file, the other won't defend, and they'll hide certain facts or even make up evidence. Bryan v. Bryan describes it as getting a divorce contrary to the justice of the case. The whole point is to deceive the court.
Okay, so how does a court spot this?
Well, the court has a duty to look for it, as mentioned in Barlow v. Barlow. But just because the other spouse doesn't fight the divorce doesn't automatically mean it's collusion. Patel v. Patel showed that the respondent just said he had no grounds to oppose. That's fine. But collusion can be inferred. For example, if there's an agreement about paying costs in exchange for not defending, or if they agree where to find evidence.
Like staging something.
Or if one spouse agrees not to ask for custody or money in return for the other not defending. Cases like Stavridis and Gabrick mention things like this. Also, if they agree to hide important facts from the court, Hubbard v. Hubbard, or if someone drops their defense because they were paid off, Gross v. Gross, if the court finds collusion happened, Section 7 of the Act says it can dismiss the petition entirely.
Right, it undermines the whole process. Okay, so that's collusion. What's connivance? How is that different? It sounds a bit similar.
Good question. They can seem close. Connivance is more about one spouse consenting to or even encouraging the other spouse committing a marital offense, usually adultery. It's like saying, go ahead, or deliberately turning a blind eye, maybe even setting it up.
So actively or passively allowing the offense.
Exactly. The classic case Godfrey v. Godfrey called it wicked and disgraceful conduct for a husband to willfully consent to his wife's adultery. If you connive at an act of adultery, you generally can't then use that act as grounds for divorce.
Okay, that makes sense. You can't complain about something you agreed to.
But there's a twist. Polden v. Polden brought up a nuance. Even if someone connived in the past, they might still be able to get a divorce for later adultery if they can show that the original connivance wasn't the direct cause of the new adultery. The idea is that the effect of the connivance might be spent. Its influence might have ended. So the old saying, once connivance, always connivance, isn't strictly absolute, though it often holds.
So the link has to be broken.
Right. And obviously, if you didn't know about the adultery, you couldn't have connived. That came up in Butch v. Butch. No knowledge, no connivance. It requires some level of awareness and consent or encouragement.
Okay, got it. Collusion is deceiving the court together. Connivance is consenting to the offense. What's the last bar? Condonation. Sounds like forgiveness.
It is, essentially. Condonation is forgiving a matrimonial offense. It happens when a spouse knows the other committed an offense, like adultery, but then forgives them, either explicitly, I forgive you, or implicitly by their actions. Section 9 of the Divorce Act is key here, especially for adultery. It says adultery isn't considered condoned unless Conjugal cohabitation has been condoned or subsequently continued.
Meaning?
Meaning just knowing about it isn't enough to count as forgiveness in the eyes of the law. There generally needs to be some kind of reconciliation, like resuming living together as husband and wife, acting as if the offense has been put behind them. That continuation of married life is usually seen as proof of forgiveness or condonation.
So taking them back, essentially.
That's often how it plays out, yes.
Good.
Resuming normal marital life after knowing about the offense usually amounts to condonation, and that then acts as a bar to divorce based on that specific offense.
Wow. What an incredibly detailed look at this. We've really unpacked the foundations of a divorce petition, the key grounds, adultery, cruelty, desertion, with all their complexities and how they're proven, and then these critical bars, collusion, connivance, condonation that act as safeguards. It really hammers home how understanding these legal terms and the cases that shape them is so vital to grasping the whole divorce process.
Absolutely. And it leaves you thinking, doesn't it? So what does all this mean for you, listening? When you hear these detailed legal definitions, the high standards for proving something like cruelty or desertion, it really raises a question. How well does the law, with all its specific rules and precedents, truly capture the sheer messiness and complexity of actual human relationships breaking down? And where do you think the line falls between just sort of unreasonable behavior in a marriage and the kind of conduct that reaches the level of legally defined, unbearable cruelty? Something to ponder.